Yes, my lord. Well, I beg to mention two motion items, my lord. It's a tender matter. One of the tender condition is that, my lord, the prospective bidders need to verify the site, and the executive engineer is required to issue a project verification certificate. And the last date is 27th. In spite of repeated requests, my lord, that has not been done.
Monday?
Can it be on, because last date is 27th, my lord, can it pray
Today
on
is what? 23rd?
23rd?
May it please your lordship. Lordship, I'm making a mention on behalf of Mr. D. Nath, lordship, in with regard to item number 2,
Okay.
appearing for the respondent, lordship,
Huh.
praying for some accommodation may it be taken up on next Thursday, lordship. Due consent of the other side petitioner has been taken.
Okay. Miss A. Devi.
M. Devi,
M.
lordship.
Devi. Learned counsel on behalf of Mr. D. Nath. Learned. Counsel for the respondents, and made a prayer for adjournment. With the consent of the learned counsel for the petitioner. Also, I have sought for and agreed to by the learned counsel. Parties, raised the case. Not next Saturday, it will be difficult. Thursday to Kinaman peacefully, no? Then the day after.
Lordships. Obliged to your lordship.
May I please, your lordship? My lord, I beg to mention number 11 and 12, my lord. My lord, these two matters, my lord, I mean, listed before Honorable Mr. Justice U.K. Dyer, my lord. Matters substantially hard, and we are directed to file written argument. We have already filed, my lord.
So, I guess so.
The last order, my lord, 22/1/2026, my lord. The order is there, my lord.
Okay.
My lord.
Mr. Nayak is there?
No,
I am appearing.
Okay. 8/61/2026 order to cycle. Mr.
T. Sheikh.
I. T. Sheikh.
My lord.
For the petitioner, although Mr. S.R. Borua, the United State Council have jointly submitted. Will you go? I'll go to him.
My lord.
Obliged.
Okay.
Daily list for motion, item 1.
No, it will finish for you. No,
May it please your lordship.
2006 or yes.
Lordship, taken instructions, Lordship. I pray that we may be allowed to approach the department once again, my lord, seeking the
Better to have a admission of liability.
yes, my lord.
Then you can proceed.
Yes, my lordship.
Or otherwise, your option is civil court.
And
That option is available.
yes,
Okay, Mr. T. Millie, learned counsel for the petitioner has submitted on instruction from the petitioner may be allowed to withdraw the petition. For collecting further details and to
verification.
and with the liberty. If with the liberty to file a case. First of all, Mr. Solia, you are there?
Yes, Lordship. I'm beginning for the finance department.
Finance, Mr. You can, any public health
Lordship.
person?
A. Gauhati was there.
I,
I got this, Lordship.
okay. Call him if he is available somewhere, so that his right to remedy is not lost. I am PH standing counsel, PHA department. And Mr. H. Oliga, standing counsel. Fine. You want to withdraw and he will try to make effort for a verification certificate. Admission of liability. For the state respondents.
Yes.
I have no objection. and have submitted that they have no objection to the affairs of the in view of the above submissions made by the learned counsel for the petitioner. The writ petition is dismissed on withdrawal, comma with their liberty as prayed for. Or
For admission, item number 3.
Any further submission, madam?
Yes, your lordship.
Yes.
Your lordship, please, your lordship. Your lordship, I have understood the question that your lordship was raising on the last date of hearing. I would like to answer every of the issues one by one, your lordship. First, your lordship, though my writ petition was filed, is filed under Article 2 to 6. However, the same may be treated as under Article 2 to 7 as well. And your lordship,
Madam,
yes, your
there
lordship.
is a difference. Have you read Stalini Shyam Sethi,
Yes, your lordship.
Radhe Shyam?
Yes, your lordship.
Right, and there are
Yes.
many things now cannot be changed. Anyway,
Yeah.
it is
Your lordship.
anyway, you should not take trouble on it because 226, if insurance ombudsman is a quasi judicial authority,
Yes,
then
your lordship.
law then 226 may be maintainable, right?
Yes, your lordship. Yes.
Right.
Yes, your lordship.
Had it been a purely civil court, 226 would not have been maintainable,
Yes, your lordship.
right?
Yes. Yes, your lordship.
On that count, you should not have much apprehension.
Yes, your lordship.
Now, next.
My submission is that only that I have brought up judgment as well. If your lordship may allow, my co-counsel would like to hand over the
Let us
judgment
see.
as well.
By every
Kiran
step,
Devi versus Bihar State Sunni Waqf Board.
we also learn. Harbans Lal, this is flowing from Whirlpool. Okay.
Your lordship, I would. I am relying for this.
Madam,
Yes, your lordship. Yes, your lordship.
your right to remedy was not foreclosed by the insurance ombudsman, right? He said, matter may be raised with the appropriate judicial authority,
Yes, your lordship.
right? And
Yes, your lordship.
that judicial authority ought to have been consumer court.
Yes, your lordship. It is consumer court also, your lordship. Yes.
Right, right.
Yes, your lordship.
So matter ought to have been raised before. He said matter may be raised with the appropriate judicial authority, and he served his responsibility to decide your complaint by
Yes, your
taking
lordship.
note of the video recording.
Yes, your lordship.
Right.
Yes, your lordship. Your lordship, I would not go into the credibility of the video recording since we have already made my submission on the last date. Your lordship,
And what more?
your lordship, for the question of this
Among the-
alternative remedy, your lordship, allow me to read the line from this judgment passed by the Honorable Supreme Court, your lordship, in Har Bansal case, your lordship.
4. That I have read, I have read already 100 times.
Okay, your lordship. Your lordship, it is clearly mentioned in this judgment that the petitioner is not barred by law to file a writ, even though alternative remedy is available, your
No,
lordship.
I'm not saying that, Madam, I'm not saying
Yes,
that
your lordship.
you are barred from filing a writ petition.
Yes, your lordship.
But I am saying on the extent to which a writ court can entertain and to decide such an issue, right? Writ
Yes, your
court and question of maintainability is not the question.
Yes.
Yes,
Right.
your lordship. Yes, your lordship.
It is the question of entertainability,
Yes, your lordship.
right? If it is entertained also,
Yes,
it
your
is
lordship.
entertainable up to what extent?
Your lordship, it can.
Certiorari says if an order of the quasi-judicial authority
Yes, your
is
lordship.
found to be infirm, it simply the read court simply sets it aside. That's all. And it
Yes,
not
Lordship.
substitute the views. Have you understood?
Yeah,
Okay.
yes, your lordship. So, your lordship, however, there is an order passed by the Supreme Court, your lordship, that the High Court may grant interim relief, your lordship. And since the
What
amount is interim relief,
Here,
your
question,
lordship,
we are into final hearing, madam. Question of interim relief is not there.
There is no final argument, no final order, then I could have power to.
It is against the final order of an authority, and we are hearing the writ petition finally. It will be a
Yes,
final
Your
order. Yes, next. Next.
your lordship, the amount, however, is undisputed, your lordship, and therefore that undisputed amount may be passed, your lordship. They were even ready to pay that amount, your lordship, before
No,
we have
madam,
filed
it
the
is
complaint.
not an undisputed issue. It is a clearly disputed issue.
Your lordship, the amount has been admitted by them, your lordship, by the respondent. 10 lakh rupees has been admitted, your lordship, in their counter affidavit, para number 3, your lordship.
Then, what more? What more?
Your lordship, my last last prayer to this honorable court is that to grant me liberty, to grant liberty to file a fresh complaint before the appropriate forum, your lordship, and to set aside the order.
Yes, Mr. Doctor.
Okay. The main dispute is between the petitioner and the respondent number 2.
Madam, I indicated to you on the last date how you could have structured your argument. Anyway, we are closing it.
Your lordship, if there is any further issues, I can answer that, your lordship, if you may allow,
Okay.
your lordship.
Well, we are closing it. That day we have heard you substantively,
Yes, your lordship.
right?
Yes, your lordship. Your lordship, I can brief the argument in 2 minutes, your lordship, if you allow, your lordship.
Okay, please.
Your lordship, on the last date of argument, I've argued how my fundamental right was violated under Article 226, and therefore we have filed this petition, your lordship. Your lordship, the quasi-judicial body of the insurance ombudsman comes within the ambit of Article 227, and your lordship has the power under Article 227 to set aside the impugned award, your lordship.
Madam, it is not 227, it is 226.
That may be treated as the same, your lordship. The judgment
It
which I've
cannot be.
provided tells the same, your lordship.
There is some bar. Then, okay. Next.
Your lordship, if I may read the line from the judgment, then it treats the same, your lordship. In Kiran Devi judgment, your lordship, para number 24. Later in Pepsi Foods Limited, this court held that nomenclature under which the petition is filed is not quite relevant, and it does not debar the court from exercising its jurisdiction, which otherwise it possesses. If the court finds that the appellants could not invoke the jurisdiction under Article 226, the court can certainly treat the petition as one under Article 227 or Section 488 of the court, your lordship. And your lordship, in para number 5, the next para, therefore, the petition styled as one under Article 226 would not bar the High Court to exercise jurisdiction under the Act and or under Article 227 of the Constitution. The jurisdiction of the High Court examines the correctness, legality, and propriety of determination of any dispute by the tribunal is reserved with the High Court. The nomenclature of the proceeding as a petition under Article 226 or a petition under Article 227 is wholly inconsequential and immaterial, your lordship.
They didn't give their fair.
Yes.
Your Lordship, they did not even give us, the insurance ombudsman did not even give us a fair opportunity to adjudicate the matter, Your Lordship. Solely on the basis of that alleged and purported video, they refused to adjudicate it.
Yes.
Your Lordship, quasi-judicial body falls within the ambit of 227, Your Lordship, and therefore it should, it comes,
Where from
Your Lordship
you
has the
have got
power for
this
judicial.
quasi-judicial body is subject to supervision of High Court under
Yeah.
227.
Your Lordship, I'm relying upon the judgment Aditya Birla Sun Life Insurance Company Limited, Your Lordship. Aditya Birla Sun Life Insurance Company Limited.
Rule number 15.
Your Lordship, in para number 15, the scheme has been mentioned of the insurance company, Your Lordship. Insurance ombudsman, sorry. Para number 15.
Rule 15 subclause.
Para number 15, subclause 4, Your Lordship. The ombudsman shall dispose of a complaint after giving the parties to the dispute a reasonable opportunity of being heard, Your Lordship. Para number 15, clause 4. The insurance ombudsman have violated this rule, Your Lordship. They have not given me a fair opportunity to adjudicate the matter. Your Lordship, if you may allow, kindly see para number 17, Your Lordship.
Yes.
It is well established that the word tribunal, as used in Article 227 of the Constitution, is required to be given a liberal interpretation to include all statutory authorities who are vested with quasi-judicial power, even though they may not have been labeled as tribunals. In this context, it would be useful to refer to the decision of the Supreme Court in Manmohan Singh Jetla versus Commissioner Union Territory, Chandigarh. Your Lordship, below this para, there is a quoted line in underlined para, Your Lordship. I would like to read that underlining lines. They are quasi-judicial authorities, and that was not disputed. Therefore, they will be comprehended in the expression tribunal as used in Article 227 of the Constitution, which confers power of superintendence over all courts and tribunals by the High Court throughout the territory in relation to which it expresses jurisdiction. Obviously, therefore, the decision of the statutory quasi-judicial authorities, which can be appropriately described as tribunal, will be subject to judicial review, namely a writ of certiorari by the High Court under Article 227 of the Constitution, Your Lordship.
Yes.
Your Lordship, kindly see para number 27 in the same judgment where it talks about the alternative remedy, regarding alternative remedy, Your Lordship. Para 27. Sorry, Your Lordship, it is para 19, and below that para, there is para number 27. Page number 309. It is equally true that a consumer who is aggrieved by the non-dressal of his grievances by the consumer forum has a range of choices before him, in that he may choose to represent his grievances before the ombudsman under subsection 6 of section 42, or he may go elsewhere in search of relief. The law protects the right of the choice, Your Lordship. And the petitioner in this case have choose to file a writ petition, Your Lordship.
Yes.
Now, Your Lordship, next I'll be relying upon the judgment Harbansal Sahnia and another versus Indian Oil Corporation. Harbansal. Para number 7, Your Lordship.
For all situations. 4 situations.
Yes,
Three.
Your Lordship.
3 situations.
Yes.
Yes, Your Lordship. 3 situations
3
have been mentioned in
situations.
this.
Don't
Yes, Your
repeat. I have
Lordship.
read it 100 times. I have said.
I apologize, Your Lordship. I apologize.
But you still could.
I humbly apologize, Your
I have
Lordship.
not addressed the point I have asked.
Yes, Your Lordship.
Okay. Close. We'll pass the order.
Your Lordship, may I make my last submission, Your Lordship. I request this honorable court for interim relief, Your Lordship. The amount, only the amount which was
Madam,
undisputed.
when the writ petition is to be disposed of,
Yes. Your
where is the
Lordship.
question of interim relief? I'm not hard of. Whatever is there, it will be final relief.
Please, Your Lordship.
Either to
Please.
either of the parties.
Please, Your
Anything to
Lordship.
be added?
No, Lordship.
Huh?
No, Lordship. In fact, Lordship, is one submission I'd like to agree. If she is really agreed that she was not given a fair opportunity of hearing as per here, that cannot be
So
denied.
we are into the 226 or 227.
Yes, Lordship.
So how
That-
much we?
Yes, Lordship.
We are 227 years. Maybe you can substitute the views.
226.
But in 226, we only examine the decision-making process,
Yes, Lordship.
not the decision. But
Yes.
if the decision-making process, in the decision-making process, he had the authority, quasi-judicial, takes into account inadmissible piece of evidence to influence his decision, then that much we can set aside the decision.
Yes.
Right? We cannot substitute and appreciate the evidence.
Yes, Lordship.
That is a matter
That-
to be
that
decided
is-
by the tribunal or forum.
That is.
That is the what we have tentatively observed. So I'll pass the order by tomorrow. It will be available. Okay.
Deeply obliged.
Lordship.
Obliged,
come
your
back at
lordship.
2.
Deeply obliged.
Yes, Mr.
My lord, here, today, one affidavit they have filed.
Okay.
So my lord, let it be after a week, my lord.
Okay, who has filed? State or
No, PNRD,
PNRD?
PNRD. Respondent number 3,
Okay. Mr. In which case?
in item 5,
Okay.
Uttam Shah.
Mr. You are in all the cases?
Oh, I am, not. I am.
Mr. M.R. Khandokar, learned counsel for the petitioners, has submitted that he has received a copy of the affidavit in opposition filed by the respondent number
3,
3 in item number 5.
in item number. Which is common for all of this.
Which, comma, respondent number 3 in item number 5. First of, he has submitted that as the said affidavit, stand taken in the said affidavit would be applicable in all, in the batch of petition, comma, he needs a 1 week time to go through the same to complete his instructions. Post of Ms. N. Bora, Learned Standing Council, Panchayat and Rural Development Department, and Mr. A. K. Doctor, Learned Central Government Council. Yes. Central Government Council. You are there, Ms. U. Das, Learned Additional Senior Government Advocate. For the official respondents are present. Post of, and have submitted that they have no, who are present, have submitted that they have no objection to appear. First of, as sought for, list the cases on Saidiba Radidat.
Second verse, 2-3.
2, 3. My lord, it is a rejoinder affidavit.
Or rejoinder.
I am deeply.
For hearings, items 9 and 10.
Industrial disputes are কিভাবে আছে না? These settlements, that much I have remembered.
Second case to long.
First was to section 17.
8150. Absolutely 8150, 10 number.
Now. But I have placed 2 of the settlements. One more settlement, which is the current settlement, your lordships may like to see that. That is at page 136.
Oh, WBC?
8151, 50, my lord. That's the first case.
That's
Personal affidavit we have filed on 17/1/2020.
1 minute. Where is the provision for settlement in the ID Act?
2P.
Settlement. Oh, section 18.
Settlement defined.
Defined is a 2P, my lord.
Uh-huh.
And section 18 is the relevant section.
Page 130. Additional affidavit. Or
71.
Filed on 17/1.
No.
Hmm.
Page 136.
136.
136. This is dated 9/11/22. And by Peter, Sota Union. Na? Signed by the management and the 6 unions. No. This is valid till 31/12/32. From 1/1/2020 till 31/12/32. 141, page 141.
141.
Yes, clause 14. At 141 below, clause 14, duration of settlement. For arriving at a settlement, the duration of the settlement has been agreed upon as follows. Listed one WCL with effect from 1/1/20 till 31/12/20. The listed one as WCL should be paid arrear on the financial aspects of the MOS with effect from 1/1/20. Then listed 2 and 3 with effect from 1/7/22 till 31/12/32. The listed 2 and 3 would be paid arrear on the financial aspects of the MOS with effect from 1/7/22. Because below the earlier settlements, the period was not, same date was not there. Therefore, there is a difference, but now all of them have been clubbed together, and this is a comprehensive settlement, and it will continue for all of them, 1/1/22, 31/12/32.
This was subsequent to filing of the writ petitions.
Yes, yes. This is, this was, date is 9/11/22.
Yes.
And effective date is 1/1/20 to 31/12/32.
Hmm.
And for some, it is 1/7/22 till 31/12/32.
These writ petitions were filed in 2017 and 2020.
Yes, 17. No?
This respondent union were not part of this.
No, this has come a little later.
No.
This is
This MOU,
No,
amount
no,
of settlement.
no. They are not part of the 6 unions. They came later into the scene from Gujarat. It is the registered office. They were registered in Bombay, and Akhil Bharatiya.
No, the issue, Amar case, not a bad case. Second. Second.
That is the second case, but
Not in this case.
not in this case.
Here, who is the respondent union?
The respondent union is O.
Mr. Dasgupta represents them.
Yes.
All India Chika.
All India Thika Shramik.
This one number 3, Oil India Thika Shramik Sangha.
Every party. Yeah, 6 unions. These are the 6 recognized union, and they were all part of this. Thika Sangha is not a recognized union. I don't. The expiry date for all will be 31/12/32. All the sections. And clause 6, my lord. Terms of settlement have been arrived at after prolonged discussions and deliberations among all signatories of the settlement. Hence, during the validity period of this settlement, there shall be no further discussion on the points settled in these terms of settlement. Thus, all the concerned parties agree that during the period of operation this MOS, no one, both on union and individual level, shall raise any further demand having financial or non-financial impact or put up any fresh demand on the issues settled in the MOS. The benefits of this MOS will not be applicable to those listed WCLs whose demand for same and similar wages and benefits and demand for regularization are sub judice before the Honorable Gauhati High Court till the outcome of the concerned cases. The benefits of the settlement will be extended to those listed 1, 2, and 3 who submit an individual undertaking the prescribed form stating that they accept all the terms of this settlement. This is the clause, earlier also there was a clause, but this has become more specific. It is subject to the benefits will come after you sign the settlement. Yeah, they accept all the terms of the settlement. All the above terms and conditions of the MOS will be implemented. That is normal. So this is the latest which is currently in force. And if your lordship just have a look at page 129. The effect of this settlement, as far as wages are concerned, there will be twofold. If you don't sign, you don't get the full benefit of this settlement. If you sign, then your income is better. That is shown below if your worships. 132. The total effect is below 132. If a worker signs this as required under this settlement, he will get below 46,254.76. If the worker doesn't sign, he loses out, but still he will get 39,943.32, which the calculation is at page 129. 39,943.30. This will remain, and he will get that amount if he has not signed. But if he has signed, it will go to 46,254.something. Difference of about 7,000 per month. That's why we had below a batch of cases. They were initially not signing. Then they realized the difference per month and loss. So they moved this honorable court with an application that this is the situation, they will be allowed. So the court directed that you apply to the government, the oil company, and then if they do, then there is no problem. In fact, they filed an application and signed the documents, and they have been given from the date of from the same date as the others, from 20 onwards. They were also members of those from military, but they came here and they got it. So that is the wage part, which is currently going on. 46,000 and all, if you have signed it, and otherwise it is 39,000 and all. Now, my lord, as far as this settlement, I placed section 18 before your lordship on the last occasion. As far as below conciliation settlements are concerned, the provision provides
So, if we come to the prayer
yes of the writ.
of the writ,
Yes,
page 28.
yes, yes.
First is the decision of the Deputy Chief Labor Commissioner that 11/9/2017.
Yes.
That is impugned.
Yes.
Next is to abide by the memorandum of settlement.
Yes.
I think this latest one is to be read into it.
Yes.
Because the memorandum of settlement in prayer number 2,
Yes.
it speaks of the earlier two memorandum of settlement.
Yes, because.
So it is to be read into new memorandum of settlement is to be read into it. That they should abide by.
Yes.
That is the.
And those who have signed.
The prayer is
getting it.
prayer stands modified.
Yes. They are getting it.
Yes, Mr.
That is his contention.
Because at the time when it was filed, only these two settlements were there, your lordship is
Okay.
right. So this has now come and it is in force and they have been paid that day. There's no problem.
So it gives rise to a situation that a number of unions have arrived at a memorandum of settlement, but two in both the petition, two are not entering into any memorandum of settlement.
Correct. They are not party. In fact, they came a little later, I think, no? Because this settlement was.
Their case is the settlement is binding on us. That is precisely what I have understood.
Yes.
That is their only case. We have a settlement and this is a conciliatory settlement and it will bind all and you are also bound by this settlement. This is what they want to say.
That is the effect of.
That is the only context.
That is the effect of section 18, Miller.
Section 18,
Yes.
once more. Yes.
Subsection 3, Miller. A settlement arrived at in the course of conciliation proceeding under this act, or an arbitration award in a case where a notification has been issued under subsection 3A of section 10A, or an award of a labor court, tribunal, national tribunal, which has become enforceable, shall be binding on all parties to the industrial disputes, all other parties summoned to appear in the proceedings as parties to the dispute unless the board, arbitrator, labor court, and so records the opinion that they were summoned without proper cause. See where a party referred to in clause A or B is an employer, his heirs, successor assigned in respect of the establishment to which the dispute relates, and D, where a party referred to in clause A or clause B is composed of workmen, all persons who are employed in the establishment or part of the establishment, as the case may be, to which the dispute relates on the date of the dispute, and all persons who subsequently become employed in that establishment or part. So that is the provision, Miller.
So
Even if you
A-
don't sign,
A and D,
Miller, basically,
there is no award of labor court
no.
or
no.
tribunal,
It is a-
so it
it
is
a conciliation settlement.
settlement arrived at in the course of conciliation proceeding under Industrial Dispute Act.
Yes,
Shall be binding on A and D,
yes,
where you want to say that all persons who subsequently
yes. Joints.
become employed in that establishment.
The
You
idea
want
is-
to bring these two unions, respondent unions,
Yeah.
into that part.
Correct. Because whoever is employed even after the award, he may not have been
Party.
espousing the cause, or he may have not been there, but subsequently you come, you get
Okay.
bound by the settlement.
So even if they are not party to the conciliation proceeding,
Correct.
but since a settlement has been arrived at,
Yes.
and this responding union join or become employed in the establishment subsequently,
Correct.
then it will be binding on them.
Them.
That is your case.
Yes, that is his case.
And Milord, I'll, as I go proceed, Milord, I'll give the relevant case law on that.
Yes.
That is a settled position.
That is the case.
Because I have not dealt with such
Yeah,
cases.
yes,
So.
So that is the, Milord, the effect of a conciliation settlement. It is actually put at par with an award of the court, or it is the highest pedestal they have put. There's some portion of the impugned order.
Page.
The impugned order is by the Deputy Chief Labor Commissioner Central,
Page 60.
space 60. Milord, a procedure which is almost known in wage fixing cases, he intimated that he will be there for 5 days. That was Julia done. Then he visits Milord the establishment, 8 of them out of 36 departments. And then a list of 13 for regular and for 14 for contract labor. He takes the statements. He doesn't examine anyone from the company. And he then passes this order and says that it's a very difficult to understand this award, because you first, there are 2 steps in the award. One is that he makes these 3 categories, which you'll also will see at page 58. Mm. 58 is regular, and regular, Milord, if your lordships kindly see the gross salary at that point of time, 27,629.
58. That is a demand.
That is the amount pay scale of a tradesman attendant grade 1 and other allowances. A regular employee who is a regular employee coming regularly through the process, he gets 27,629. Now, if your lordships turn over to page 59, your lordships finds now the first take listed one. His total comes below 26,597.46. Now, first step is he makes them 27,629 regular persons total salary by adding whatever is required to make it 27,629. For example, 26,597.96. He has added first 1,032 so that it becomes equal to the regular employee, 27,629. Similarly, he did that to the second category. The amount is 2,064 he added, and then it becomes the 27,629. And the third category, total wages was 16,998 only. Now, what he does for that, your lordships will kindly now turn to the connected page at page 80. Now, kindly turn to page 80.
What is WCL? Work charge contract level.
Yes. So, by this, my lord, he is giving the final payments. Now, kindly see, so far as the this is the regular yes, security. So he starts with 27,629 because he has added those money and made it comparable to the regular gross salary at that time. And then added, my lord, 5,000 for listed one, 32,629 it becomes. Then second category, 2, listed 2, he added 3,000 to that amount, and it becomes 30,629. So far as this 3 is concerned, your lordship has seen at page 59, they were getting only 16,998. Now he is making it 27,629. That just means adding another 10,000 something. So this is how, my lord, the award was given. And similarly, in the second category of medical attendant and then cleaner and helper, the starting is 27,629. Then his own gift of 5,000, 3,000, and my lord, total is 10,000 for the third category. So that is how, my lord, he has calculated and done the thing, for which your lordships will not get a proper reason as to why he is adding so much in revision of wages. You know, the wage fixation, if it is done this way, my lord, it will have no meaning, because if your lordships movement of this entirely plantation tea garden wage fixations, they are also done on a union level and the employer level. So it is a hard bargain for months together, even for raising the salary from what it is to say 2,000 more. Even that is contested, and ultimately I don't think even till today they have been successful in getting a daily wage of more than 250. So for the tea garden employees are concerned. So this is how, my lord, the matter was dealt with. First is, my lord, your lordships, the required approach, because it's a power of fixing wages and not for a small unit, it's a big oil company with so much my lord, different sort of levels and different my lord, areas of operation, because it's a company where my lord, they will first explore whether there will be some oil somewhere, and then they will have a seismic survey. Then if it is found, then there will be drilling. So that process itself is a labor-intensive area. But ultimately, sometimes you don't get any oil, finally, and then the whole exercise is becomes useless. Or if you get, you are lucky, but you don't. Nature of the industry is such that you cannot afford to have all the laborers which are required at the stage of that exploration or at the time of drilling. Therefore, these aspects are relevant aspects. Now, how will you know if you don't get somebody from the employer to explain why this sort of wages are paid and why there is that difference between a regular employee's wage and a casual employee's wage? Because this is something which is permissible under the law, engagement of contract labor, because there is an act which specifies the employer has to be registered, the contractor employed has to have a license, and all the provisions are mentioned in the act, and that protects the contract labor. So if you do not abolish contract labor, which is also the act provides for as a power of the central government, Section 10, then, my lord, you have to understand that if you fix wages, you have to keep relevant aspects in your mind. Apart from the question of the parity, which, as your lordships know, there is a whole line of cases where the different aspects are mentioned by the High Court as well as by the Supreme Court. Therefore, if you increase wages in the manner in which it has been done, with all respect, it is going to have a deep repercussion on the entire industry. So this is the formula virtually he has adopted, for which he has not given as to why he is giving 5,000 to some, why he is giving 3,000 to some. That is how the exercise has been done. I placed, my lord, before your lordship the finding after discussing everything, page 75.
Yes.
He records a finding here. After perusal of the above statements of contract workers and permanent employees, it is a fact that there is no total similarity in the job contents of both types of workmen. But it has also been established there is similarity in the job contents of these workmen to a great extent, with a few exceptions. The contract workers categorized as 1, 2, 3 in the shops and sections of the oil production, gas, field communication, electrical engineering, materials, civil, oil and gas production service are working since long and have acquired sufficient skill and knowledge of their work. They have worked in other shops and sections also, so that they are having varied work experience. They have proved their utility by helping the management in core activities of the company whenever engaged. The permanent employees may have different nomenclatures. So far as their designation is concerned, but they are performing almost same type of job as that of a contract workers. The duty hours of the contract workers are same in comparison to permanent employees. It was also observed during the inquiry that the permanent employees, although supervising the work of contract workers in some cases, are also doing the same work as a team. And there is no differentiation in the nature of job of these workmen. The inquiry was conducted on random sampling basis. It has also come to the notice of the authority that there are many field stations of the company where contract laborers are not performing the same job as being done by the permanent employees, so there cannot be any comparison in respect of job contents of both types of workmen engaged in these stations. As such, justice demands that the contract workers in the category of WCL 1 performing the job of cleaner and helper in shops and sections like production, oil, production, SS, production, gas, field communication, electrical materials, civil oil and gas production service of Oil India Limited at Duliajan and figuring in the list of the union should be given rupees 27,629. That is his adding to this existing salary. Towards wages plus 5,000. This is how he is fixing the wage. On account of one-time fixation benefit per month. So far, as contract workers in the category of WCL listed 2 performing the job of cleaner and helper in the above shop sections figuring in the claimed list of the union are concerned, they should be given 27,629 towards wages plus 3,000 as one-time fixation benefit per month. The contract workers in the category of WCL 3 engaged as cleaner and helper in the shop sections whose names figure in the list of the union should be given 27,629. That means from 16,000, that category below, to 27,629, the rise of 10,000 towards wages per month. Other benefits like annual increment, leave, etc., admissible to WL 1, 2, 3 should remain same as per existing memorandum of settlement. So the other benefits also come from the settlement, but wages he has fixed in the manner he has indicated in this paragraph. The next paragraph, Milord, I may just read out also. After the evidence of contract workers and regular employees were taken, the management of Oil India and the concerned union were advised to give their final statement. The management of Oil India submitted its final written statement by letter dated so-and-so, wherein they reiterated the terms and conditions of the memorandum of settlement in operation dated so-and-so, through which disputes relating to wages and benefits of listed contract workers have already been settled. The memorandum of settlements specifically stipulates that no dispute, including wages, whatever settled under these 2 memorandum of settlement, should be raised during the currency of the operation. The 10 years of the memorandum of settlements up to 31/12/29 and 36/22 respectively. Further, the management also reiterated the settled principle of law as laid down by the Apex Court in various cases also states that although equal pay for equal work is considered to be concomitant of Article 14 of the Constitution, inasmuch as equal pay for unequal work will also be a negation of that right. Equal pay would depend upon not only the nature of the volume of the work, but also on the qualitative difference as regards reliability, responsibility, and though the functions may be the same, but the responsibility do make a real substantial difference. In addition, the degree of skill and various dimensions of a given job are also determining factors of establishing parity of the 2 categories. The permanent employees of Oil India were recruited through competition. As per the laid down recruitment and promotion policy, on the basis of the policy, the workers were recruited through open direct recruitment. by compulsory notifications to concerned employment exchange and also through advertisement in local newspapers, because that is our established normal recruitment procedure for regular employees. The recruitments were made subject to fulfillment of different criteria, including success in a strict selection process, whereas the contract laborers are not required to pass through aforesaid conditions and criteria for their engagement so as to claim parity with the permanent employees of the company. It is also pertinent to mention that there was intense competition for selection to the posts of tradesmen and attendant. Thus, there is a substantial difference between a contract laborer engaged in oil and the regular employees of oil in terms of education, qualification, skill, selection process, experience, responsibility, accountability, initiative, reliability, trustworthiness, and disciplinary procedure for misconducts, etc., for which they cannot be judged to be performing same or similar kind of work. Hence, the authority should reject the prayer for complainant of some or similar wages as the same is not tenable in fact as well as in law. The union, while its later submitted written statement wherein they stated the company is engaging works contract to contractors and the OCL is discharging its duties and obligations as principal employer. The demand raised by this union under section 25F is at par with the provisions of the relevant acts and rules, and this union is quite justified in raising such demands. While 25(4) of the same Act as referred by oil prescribed that the rates of wages payable to the workmen of the contractor shall not be less than the rates prescribed under the Minimum Wages Act. The said provisions of the Act categorically prescribe the minimum rates of wage below which the rates of wages should not fall. The relevant Act and the rules for the time being in force has not prescribed the upper limit of the wages. The OITS thus has not misled the authority concerned by raising their demands under so and so and so and so. So it's very difficult to understand the logic behind the fixation and the rise. This is how he goes on. 79. And he recognizes below that for the regular employee, different qualifications, mode of recruitment, everything, competition, all are there, that is recognized. Then middle 78, last paragraph, your lordship can move. The management in its final written statement dated so-and-so has referred to terms and conditions of the settlement dated these two, which are still in operation, and submitted that no fresh demand and similar wages at par with permanent employees or otherwise can be raised by contract workers benefited by the aforesaid settlements through any union. The authority is of opinion that the contention of the management is not correct in this regard, since it amounts to contracting out by the workers, which is not permissible under the world. Absolutely contrary to what section 18 has provided. The provisions of 25(5)(a) of the central rules are statutory provision, and these cannot be overruled by any settlement. The demand of the union in the present case is in line with the provisions of Rule 25, which provides that in cases where the workman employed by the company perform the same or similar kind of work as the workman directly employed by the principal employer of the certain wage rates and other works and conditions of service of the workman or the contractor shall be same as applicable to workman directly employed by the principal employer of the establishment on the same and similar kind of work. The authority has come to the conclusion after inquiry of concerned sections that contract workers 1, 2, and 3 mentioned in the list of the union are performing same and similar nature of work in comparison to permanent employees in these shops and sections, so that union is justified in raising the demand for the benefits of Rule 25 of the rules, at least in respect of concerned contract laborers. Moreover, Section 31 of the contract labor also provides that provisions of this shall have effect, notwithstanding anything consistent therewith contained in any other law or in terms of any agreement or contract of service, or in any standing orders applicable to the establishment, whether made before or after the commencement of the act. And then, I skipped it next two. It is a fact that the recruitment rules of permanent employees are different compared to contract laborers, but so far as skill, knowledge, experience, responsibility, accountability, initiating any reliability and trustworthiness of contract laborers are concerned, it is not less than the permanent employees. The contract laborers are working for since long, and they have acquired sufficient skill and knowledge of their job over the years. They have proved their utility also in this regard with full responsibility and accountability by performing satisfactory and quality work wherever posted. They have been engaged through contractors, but it is also a fact that contractors are changing, whereas the contract laborers remain the same. These contract laborers are assigned duties by the management directly, and the contractors are for namesake. The administrative and economic control over contract labor are exercised by the principal employer, so we may call it a sham contract. Moreover, the assumption is further strengthened by the fact that the memorandum of settlement dated so and so have been signed by representatives of the principal employer and the trade unions representing the categories of 1, 2, 3 under the provisions of the Industrial Disputes Act and rules made therein. It doesn't bear the signature of any contractor engaging these contract works. The union in its final written statement dated so and so has also echoed the same views. Further, it has been correctly pointed out by the union that the writ petition 2469 lying before the Gauhati High Court pertains to the regularization of works of contract labor and not for providing same and similar wages and other benefits in terms of the provisions of 2525A. As such, both these cases are different and it has got no similarity. Now, this case again, 2469 has been disposed of as infractions. And then, Milord, in view of the above, perhaps keep the next paragraph. In view of the above, contract workers categorized as 1, 2, and 3 engaged by law mentioned in the application of the union, and in respect of whom an inquiry has been conducted by the authority under Rule 25 or 25A of the contract labor and central rules of 71 have found to be performing the same and similar kind of work as of regular employees of the company for pretty long time. Hence, their monthly wages should commensurate with their volume of works, hours of works, weekly off, and other conditions of service with a view to bring about parity in comparison to regular employees to the possible extent. As such, the wages of these contract workers is fixed in the following manner. So that is how he has fixed it. You know, if there is a element of consistency missing, because 75 says that they are different, they are not identical. And he also refers to the relevant considerations which are required to be taken in considering this kind of a situation when a pay parity demand is made. And he comes to that conclusion that by a process which is very difficult to understand, because he doesn't justify why he is adding the 5,000 and 3,000, and also that 1,000 to make it 27,000 of the regular contract labor. So this is how it is given. Now, my lord, if I just indicate if, because the whole process is, my lord, who is going to decide the wages? The company, not the contractor. Now, how, suppose there is a demand that there should be a revision. Who has to be hurt in the matter? Obviously, the company. Contractor may be a party to the proceedings of conciliation, because under this statute, the responsibilities of the contractor to pay, in default, the employer will be paid, and the principal employer pays to the contractor. And the records are maintained by the contractor, and therefore, my lord, contractor has a role. But no, neither the contractors have been called, but more importantly, because contractor only supplies labor, so he will also not be able to say what is the difference between these two types of same designated workers. That is only an employer can explain why they are having some regular employees and why they are having some contractual employees. If you don't hear them, how do you determine the wages? That's the most essential and preliminary thing, because you must get it from the employer as to what is their case, why are they having this, what is the rationale in having different types of workers, casual and permanent. So these are factors which have to be told to the court by an employer. The contract laborer himself or the permanent employee himself will not be able to explain why it is done that way. Every company will have its own policy. So if you are going to say that these are all too same, which the company is not maintaining or not keeping in the wage scales, then the first thing you have to do if you are going to revise these wages is to call for, you may call the workers from regular and contractual. I am not saying you need not do it. You can bring it. But the primary person who will be able to explain why this process is being maintained by the company, what are the reasons that you need so much of contract labor in an industry of this type. These are factors which are relevant in fixing wages. Now, if you don't get anybody from the employer side to explain that, what kind of a wage fixing procedure you are adopting, that absolutely vitiates the entire process, because this is a very serious matter so far as the company is concerned, because it is, if the award has to be implemented, it will mean a whole different story as far as wage fixation is concerned, because a huge number of contract laborers are needed for this kind of an industry, and the explorations always do not give the due return. Therefore, you must take into account those factors and also understand why some people are brought on competitive process as a regular employee and why they are not. That only an employer can explain, which is not now, he has not done it, and he is giving contradictory findings. He says it's not identical. Then he said that no, they're doing the same thing. So it's all blurred sort of approach and blurred sort of findings which are right there. Now I'll draw your lordship's kind attention. What is the implication of this approach he has taken? And I'll read out a few paragraphs from the petition to indicate what approach he has taken and how it has gone wrong. If your lordships kindly turn to page 18.
One five.
18,
One.
paragraph 17.
Yes. Yes.
That the paragraph 17, that the petitioner begs to state that a mere reading of the impugn order will show that the respondent number 2 was totally biased against the petitioner company, and apparently he has converted the first application of the union to an application under Rule 25 of the rules. It is not understood as to how the respondent number 2 can compare an unskilled workman job with that of a job of a junior engineer who is a highly qualified technical person. The respondent number 2 was fully aware that oil has its permanent workmen from grade 1 to grade 9. Grade 1 is the starting, and as you go, you get to the promotion. And a unskilled regular employees who enters into grade 1 of the regular skills require around 25 years to enter into grade 9. Even for a regular employee, he has to get the promotions, and then the time which will be required about 35 years. After appearing in the written examination and vivacy for promotion to the next higher grade, provided the vacancy arises in the next higher grade, the highly technically qualified persons who have passed and obtained apprenticeship certificate under the Apprentice Act or a degree from an ITI with technical qualification are only recruited to grade 5 after written oral and trade test. Accordingly, and unskilled contract laborers cannot be equated with a skilled workman, as has been done by the respondent number 2 while passing the impugn order. In this regard, the petitioner begs to state that a regular employee who enters into a grade 1 after going through the written and vivacy gets a total monthly salary of 27,806 in comparison to the monthly salary of listed WCLs, who does not come through any such selection process and gets a total monthly salary of rupees 26,597.96 in respect of listed 1 WCL, whereas listed 2 and 3 gets monthly salary of 25 so much and respectively on 3967, 970. That your lordship has seen at page 58, 59. That the petitioner company begs to state, why am I referring to the grade 1? Because your lordships will kindly see, ultimately he has also in the judge order 65 opinion. Your lordship gets the grades at page 65. He is mentioning the names of the contract laborers at page 64. And page 65, I am trying just to show that these 13 regular employees whom he has taken as a yardstick for comparison. See, Millard, kindly see first case, paramedical technician, SGB, grade 8. He is comparing with grade 8, then Millard, grade 5, then grade 5 again, then grade 7, grade 9, 8, 5, 5, 9, 3. So these are the grades of people whom he has taken and on whose comparison he has come to these conclusions, which are also somewhat contradictory in itself. Then we'll kindly turn over to page 19, para 18. That the petitioner company begs to state by impugn order dated so and so the respondent is trying to bring on the equal pay for equal work by comparing the work of regular employees of the company working in grade 5 to 9 with that of the contract laborers who are performing unskilled work. A regular security guard after getting promotion from grade 1 to 5 will necessarily earn more than the any other regular security guard in grade 1. Accordingly, comparison of a security guard of grade 5 with a contract laborer engaged through contractor will have no meaning, as the respondent number 2 in his own impugn order has admitted that the regular grade 5 security guard is responsible for the duties of the workmen engaged by the security agencies and contractors, which itself shows that regular security guards has not only the duty of opening and closing of ward and office rooms, but he has also to supervise the work of other security guards engaged through the contractor. However, the respondent number 2 did not take into account of the said vital aspect, which has vitiated the entire reasoning, and as such the impugn order is violating of Rule 25, as well as the principle of equal pay for equal work, and as such the entire impugn order is liable to be set aside and quashed. Similarly, with the medical attendant, we have indicated the regular attendant who is whom he has taken. For example, Milot at 20, para 19, petitioner begs to say that similarly, respondent while dealing with the case of medical attendant, compared a contract laborer with a paramedical technician of grade 8, which itself amount to comparing a highly skilled person with an unskilled workman. Admittedly, a paramedical technician of grade 8 is highly skilled employee recruited directly as per company's recruitment process, who can provide all medical assistance in emergency to a patient, even in absence of a doctor. However, a contract laborer who is working in medical department, taking patients to the CT scan and X-ray room and doing bed maintenance cannot be held to be performing the same and similar kind of work like that of a paramedical technician, nor it can be held that he is performing equal work that like of a paramedical technician to get equal pay. Failure to consider these vital aspects of the matter itself shows that the respondent number 2 by hook and crook tried to give benefits to contract laborers to some extra payment, which they are not entitled under Rules 25, as well as the principle of equal pay for equal work. Similarly, Milad, we have gone through all the other categories and indicated the yardstick which has taken, which is of a higher grade and requiring skill and educational qualification and everything. So, and these paragraphs, your Lordship may note that this has not been denied at any stage. Therefore, if these facts are not rebutted, then it remains, and he has failed to take account of relevant facts, which, who is that? That's why it is very important in these matters, Milord, that you hear the version of the real employer, because he knows what he is doing. The policy is really adopted or enunciated by the management. So some management person you have to have, so far as this waste fixation is concerned, otherwise you will get into a mess of this time. And the new unions members have availed the benefits of the new settlement. That we have mentioned at page 22 and paragraph 23. Because by virtue of page 69. Hmm. Hmm. If your lordship's, my learned friend is rightly point out, page 69, category C cleaner. And page 72. Last statement of visit check as a junior engineer. Roman 2. He's been considered, and we have mentioned this in our paragraph 22. No? Paragraph 20. He's a regular employee. At page 72, below statement of Obijit Shaikya, he submitted that he is working as a junior engineer to presently posted at field communication as permanent employee on the role of message since 2016, having oil number so and so. He is a diploma holder in electronics and telecommunication and placed in grade 9. He is performing the work of supervising a plane. He is a technically qualified person, you know. Is he? Yeah. He knows. And that is, we have averred that in paragraph 20, at page 20. The petitioner company begs to state that respond number 2, while passing the impugned order, compared a number of cleaner and helper with the junior assistant 1 of production oil in grade 5, operator of operation in grade 8, assistant operator, grade 5 of production, gas and junior engineer 2 of grade 9 in field communications, mechanical grade 2 and grade 8 of electrical engineering with the contract laborers. The response number 2 was fully aware that those regular employees of grade 5 to 9 were all skilled employees having either their electrical license or diploma in telecommunication or diploma certificate under apprenticeship. Accordingly, the response number 2 would not have compared highly skilled technical employees recruited directly as per necessary recruitment guidelines with the unskilled contract laborers. It's a settled law that equal pay must depend upon the nature of the work done. It cannot be judged by mere volume of work. As there may be qualitative difference as regards reliability and responsibility. It is also a settled law that different pay scales having regard to different educational qualification. Page 21, paragraph 24. At page 21. Accordingly, the comparison made for the cleaner and helper are without any basis and cannot stand the scrutiny. In the and then 21 also similarly, the basic that is different. contractor not a party. That point was taken. More than anything else, my lord, these are all undisputed before your lordship. But I am not asking your lordships to decide on these facts. Because the area of that comparison should have been at the level where the wage fixing authority is taking up the job. He has not done that work. He has not called the employer. So how do you revise and come to a conclusion that they should be given the same rates, with an implication which is so staggering, because this is a very labor-intensive industry. And for example, if you get a new settlement and you want to have a seismic survey or a drilling afterwards, you need a whole lot of contract laborers, because you can't afford, the industry can't afford, nowhere they can afford this. If they have to employ about 2,500 people for that job, suppose you do that regular basis and the oil doesn't come, you don't discover the oil at the end of the day. So these are very many problems in the oil industry. And our own consumption is only 34% or something of the requirement. Therefore, it has an impact on the economy also in a broader way. But the whole problem is, that if you had called somebody from the management side, you would have get these persons which are relevant. Therefore, if you proceed with two different findings, namely, first you are saying that yes, it is not identical. Then you say that no, but you see, you can still say they're doing the thing. But that is not the approach for fixation of wages. It will have serious repercussions on the industry. No evidence taken. Nobody knows. He calls only the regular employees and contractual employees. They can say that we are doing this, but the intricacies, the qualifications, he is oblivious. You have gone to 8 departments out of 36 departments. This is hardly the way you fix rent. And on a matter, where the section says, how do you pay the wages? Either the minimum wages at the bottom, or if you have a settlement, as per the settlement's terms, and then comes, if you are comparing and getting to a situation where all of them are really same level of, educationally same level, and then technically equally competent, then those parameters, if you apply to both categories, you come to a finding that they are equal. But your finding itself shows that they are not identical. If it is not identical, how do you give them the same parity of wages? It is absolutely self-contradictory. At that point of time, settlements were existing. They are continuously existing even now. And they are getting the benefits, And as I told your lordships, 2010, the first agreement, that brought the basic of the regular scale to these contract laborers, which ultimately, if it is regular, that is what was given in that 2017 Supreme Court cases, Jagdish Singh. So there, ultimately, what are you talking about? You are talking about how much an employee takes home at the end of the month. It is an amount you have to take into account. And if you see that this account is not negligible compared to what is prevailing in the entire state, in different employments, then you can't interfere in the way you have done it, without taking into account the relevant aspects. And you, the entire award your lordship will never get. Why he is becoming magnanimous to give 5,000, 3,000, and then initially those 1,000s to make it 27,629. That has become the parameter. And then 16,000 also becomes 27,000. Unthinkable, I have not seen anything of this kind in West fixation. And I'll just indicate because copy this one. Acts contemplation of a minimum wages as per the Minimum Wages Act. We commoners see, no? The unskilled person, total amount will be, if he works for 26 days, 12,844.
Which part?
That is unskilled, the lower part,
Mhm.
C area. C area is Assam area.
Page, first page.
Yes, I'm looking at first page or second page? First page.
Notification.
The notification. Details.
C area 577.
Bigger loss fund.
577.
Milot. This is unskilled, Milot. Unskilled is
490.
350 in C area, that is our Assam area.
C area 350.
350 plus 144 is equal to 494. Into 26, it will be 12,844. If it is monthly, it will be a little more. Per day, it was 494. And wages are for only 26 days for contractual. So it comes to 12,844. If it is 30 day Monday, it will add another, say, roughly 4 days and 2,000 more, 14,000 now. And if you also see the minimum wages given highly skilled also, what is his rate? 816 plus column 579 plus 237, 816. And if you pay for 26 days, it is 24,480. That is highly skilled workers. And they are getting under the settlement. If you have those who are not disputing it, he's getting 46,000. And those who are disputing, they are also getting 39,000 and all. That's why some batch of people came before this court to get the permission to sign and get the thing. Now, my lord, I will come to the judgments. You can change it. Will you close? 98. Given a copy to- My lord has been given a copy, so I have we have given the conciliatory settlement is binding upon the parties and in
Yes.
this case. 98-1 SCC 650, paragraph 789. And into 11. It was in my ticket. My lord has the copy of the judgment also. Paragraph 7, 8, 9, 11.
7, 8, 11. 7, 8, 11.
Yes. 13 also. Okay. My lord, your lordship has a bound volume. no?
Yes.
Yeah, that will be page 8. Huh? You give me the pages. This is paragraph 6. Then kindly turn to paragraph 7. then.
Yes. Yes.
May I just place from paragraph 6 below, that will be
Six.
better, I think.
Yes.
In order to appreciate the aforesaid, that is at page 7. In order to appreciate the aforesaid contentions canvassed by counsel for the appearance, it will be necessary to have a look at the statutory scheme of the Act. The Act is enacted for resolving industrial disputes between workman and employer, which would have pernicious effect on industrial peace and industrial production, and which would in their turn adversely affect the economy of the nation as a whole. The Act is enacted to make provisions for investigation and settlement of industrial disputes and for certain other purposes mentioned in the Act. Under the Act, the principal techniques of settlement of disputes are collective bargaining, mediation and conciliation, and investigation, arbitration, and adjudication. The scheme of the Act shows that adjudication is to be resorted to in the last alternative. Before any matter is referred for adjudication under Section 10, there should be an attempt at conciliation. As laid down by this court in Harvardson versus Workman, any settlement between the employer and the employees is placed on a higher pedestal than an award passed after adjudication. It is easy to visualize the individual workmen have by themselves scant bargaining power. Therefore, their disputes have to be highlighted by their
Bargaining with them.
by their bargaining agents, namely their unions, representing the body of the workmen, so that the bargaining power of individual workmen can get strengthened. As per Section 36 of the Act, a workman is a party to a dispute shall be entitled to be represented in any proceedings under this Act by any member of the executive or other office bearers of a registered trade union of which he is a member. The machinery of the Act envisages resolution of industrial disputes and conflicts at the grassroots level by conciliation, by which settlement can be arrived at between the employer and the workman, and industrial peace can be achieved, and industrial strife can be put to an end. The Act envisages two types of settlements between the warring groups of employer and employees. As defined by Section 2P of the Act, settlement means a settlement arrived at in the course of conciliation proceedings and includes a written agreement between the employer and the workman arrived at otherwise than in the course of conciliation proceedings, where such agreement has been signed by the parties thereto in such manner as may be prescribed, and a copy thereof has been sent to an officer authorized in this behalf by the appropriate government and the conciliation officer. Thus, a settlement which is based on a written agreement between the parties can be arrived at either in conciliation proceedings or even outside the conciliation proceedings between the representatives of the workmen on the one hand and the management of the other. But even if such written agreement signed by the parties arrived outside conciliation proceedings, it would become a settlement once the prescribed procedure is envisaged by Section 2P is followed. So far as the settlements arrived at in course of conciliation proceedings are concerned, Section 12 of the Act deals with such settlements as laid down by Section 12(1), where any industrial disputes exist or is apprehended, the conciliation officer may by Section 22 has been given, shall hold conciliation proceedings in the prescribed manner. Subsection 2 of Section 12 enjoins upon him for the purpose of bringing about a settlement of the dispute without delay to investigate this dispute and all matters affecting the merits of the right settlement thereof, and to make all efforts as he thinks fit for the purpose of inducing the parties to come to a fair and amicable settlement of the dispute. Then follows subsection 3 of Section 12, under which settlement in the present case saw the light of the day. It reads as under: if a settlement of the dispute or any of the matters in dispute is arrived at in the course of conciliation proceedings, the conciliation officer authorized in this behalf by the appropriate government, together with a memorandum of settlement signed by the parties to the dispute. Subsection 745 of Section 12 lays down that if no settlement is arrived at, the conciliation officer shall submit a full report to the appropriate government, which, if satisfied that there is a case for reference of the dispute to board, labor court, tribunal, or national tribunal, as the case may be, he may make such a reference and shall record and communicate to the parties concerned its reasons therefore. So far as the settlement arrived at outside the conciliation proceeding is concerned, Section 18(1) deals with such settlement and lays down that the settlement arrived at by agreement between the employer and the workman, otherwise than in the course of conciliation proceedings, shall be binding on the parties to the agreement. Subsection 3 of Section 13, however, deals with the settlement arrived at during conciliation proceedings and lays down that we are concerned with this entry. Then it is quoted below. Turn over the page.
Yes.
Parity. The aforesaid relevant provisions of the Act, therefore, leave no room for doubt that once a written settlement is arrived at during the conciliation proceedings, such settlement under Section 12(3) has a binding effect not only on the signatories to the settlement, but also on all parties to the industrial disputes, which should cover the entire body of workmen, not only existing workmen, but also future workmen. Such a settlement during conciliation proceedings has the same legal effect as an award of labor court, tribunal, national tribunal, or an arbitration award. They all stand on a par. It is easy to visualize the settlement contemplated by Section 12(3) necessarily means a written settlement which would be based on a written agreement where signatories to such settlement sign the settlement. Therefore, the settlement under 12(3) during conciliation proceedings and all other settlements contemplated by Section 2P outside conciliation must be based on written agreements. Written agreements would become settlements contemplated by Section 2P, read with Section 12(3) of the Act when arrived at during conciliation proceedings or even outside conciliation proceedings. Thus, written agreements could become settlements after relevant procedural provisions for arriving at such settlements are followed. Thus, all settlements necessarily are based on written agreements between the parties. It is impossible to accept the submission of the learned counsel for the appellants the settlements between the parties are different from the agreements between the parties. It is tried to observe that all settlements must be based on written agreements, and as such, written agreements get embedded in settlements. But all agreements may not necessarily be settlements till the aforesaid procedure giving them the status of such settlement gets followed. In other words, under the scheme of the Act, all settlements are necessary to be treated as binding agreements between the parties, but all agreements may not be settlements so as to have binding effect as provided under section 18(1) or 3 of the necessary, if the necessary procedure for giving them such status is not followed in the given cases. On the aforesaid scheme of the Act, therefore, it must be held that the settlement arrived at during conciliation proceedings on 5580 between respondent number 1, management on the one hand, and the 4 out of 5 unions of the workmen on the other, had a binding effect under section 18(3) of the Act, not only on the members of the signatory unions, but also on the remaining workmen who were represented by the 5th union, which, though having taken part in the conciliation proceeding, refused to sign the settlement. So it doesn't matter whether your union has signed or be a party to it or not, everyone will be covered by this settlement. It is axiomatic that if such settlement arrive at during the conciliation proceeding is binding on even future workmen, as laid down in section 18(3)(d), it would ipso facto bind all the existing workmen who are all parties to the industrial dispute and who may not be members of the unions that are signatories to such settlement under section 12(3) of the Act. In para 9, Milord, there is only one thing, about 6-7 lines from the top. The unions espouse the common cause on behalf of all their members. Consequently, settlement arrived at by them with management would bind at least their members, and if such settlement is arrived at during conciliation proceeding, it will bind even non-members.
Which line?
Milord 9, para 9.
Yes.
About 8 lines from the top below. The reins of bargaining.
11th line.
11.
Yes.
The reins of bargaining on his
Union
behalf are
espouse the
handed over to the union representing such workmen. The unions espouse the common cause on behalf of all their members. Consequently, settlement arrived at by them with management would bind at least their members, and if such settlement is arrived at during conciliation proceeding, it would bind even non-members, because even future employees who will come, they will be bound by this. Thus, settlements are the live wires under the Act for ensuring industrial peace and prosperity. Section 10(2) of the Act highlights this position by providing that where the parties to an industrial dispute apply in the prescribed manner, whether jointly or separately for a reference of the dispute, courts, lower court and national tribunal appropriate if satisfied that the persons applying represent the majority, each party shall make the reference accordingly. Individual workman comes into the picture, then it's not so much mystery. Then kindly turn over to paragraph 11. Paragraph 11 at 661. In Barauni Refinery versus so-and-so, Ahmedi J, as he then was, speaking for a bench of 2 learned judges of this court, had an occasion to consider the binding effect of such a settlement arrived at during conciliation proceeding in the light of the section 18 of the Act. The following pertinent observations in these connections were made. A settlement arrived at in the course of conciliation proceedings with a recognized majority union will be binding on all workmen of the establishment, even those who belong to the minority union which had objected to the same. To that extent, it departs from the ordinary law of contract. The object obviously is to uphold the sanctity of settlements reached with the active assistance of the conciliation officer and to discourage an individual employee or a minority union from scuttling the settlement. There is an underlying assumption that a settlement reached with the help of conciliation officer must be fair and reasonable and can therefore safely be made binding not only on the workmen belonging to the union signing the settlement, but also on others. That is why a settlement arrived in the course of conciliation proceedings is put on par with an award and made by the adjudicatory authorities. And then it goes on to something. You? And these are clauses which are there in the agreement itself, you know. Page 34 and page 40.
Page?
Page 34 and page 40 is similar. First agreement, page 34.
34.
Clause 8. This is a normal clause in any kind of agreement or settlement. It has been agreed by the unions as well as by the beneficiary listed WCS that the above settlement is in full and final settlement of all their demands. Neither the unions nor any individual listed WCL. Page 34.
Page 34.
34. How do you read?
Read please.
Of the first agreement of 2010.
Yes.
Clause 8. The above settlement is in full and final settlement of the demand. Neither the union nor individual listed who will be availing the benefits will raise any demand or dispute whatsoever on any of the matters settled therein and on any issue raised in the charter of demand, including the matter of regulation during the tenure of this settlement. In the event of raising of any demand and dispute on any of the said issues where the union individual listed purchase, the settlement would stand cancelled and the benefits under the settlement would stand withdrawn in respect of the concerned Judicial members of the concerned union. Next, page 40 is a similar clause below so far as the second is concerned. Clause B at page 40. This is a normal clause of a settlement. This judgment also will have a bearing when my learned friend will make an argument on the basis of section 30, but I will not trouble your lordships now. This in fact make submission. National Engineering 2000, next case is 2000, volume 1, SCC 371. There are 24 and 25 below. Hmm? 392. Oh. Page 39 of your lordships.
Yes.
Volume 24. It will be thus seen that the High Court has jurisdiction to entertain a writ petition when there is an allegation there is no industrial dispute and none apprehended, which could be subject matter of referral for adjudication of the answer. Here it is a question of jurisdiction with the tribunal, which should be examined by the High Court. That issue is not here. Next 4 lines, a settlement of dispute between the parties themselves is to be preferred, where it could be arrived at to industrial adjudication, as the settlement is likely to lead to more lasting peace than an award. Settlement is arrived at by free will of the parties and is a pointer to their being goodwill between them. When there is a dispute, that settlement is not bona fide in nature or that it has been arrived at on account of fraud, misrepresentation, or concealment of facts, or even corruption and other inducement. It could be the subject matter of yet another industrial dispute, which an appropriate government may refer for adjudication after examining the allegations, as there is an underlying assumption that the settlement reached to the help of conciliation of must be fair and reasonable. So, my lord, if anyone wants to contest a settlement arrived at during the course of conciliation or even otherwise, he may have to he can be in a position to raise a dispute, but not for the merits of the case, but for other reasons as mentioned in here. Namely, that if there is a fraud or if there is unnecessary inducement, and if it is otherwise concealment and all that. So that has to be, if you have a grievance of that type, you have to raise a dispute, which can be referred for adjudication, and if the court finds that there is substance in what is being said, then that award can be touched. Otherwise, normally an award will remain during the course of its existence. Settlement. When there is a dispute that the settlement is not bona fide in nature or that it has been arrived at on account of fraud, misrepresentation, or concealment of facts, or even corruption and other inducement, it could be the subject matter of yet another industrial dispute, which an appropriate government may refer for adjudication after examining the allegation, as there is an underlying assumption that the settlement reached to the help of the conciliation officer must be fair and reasonable. So that's the normal presumption. But if you are going to raise a dispute about that conciliation, you have to raise an industrial dispute. But it can be a normal industrial dispute. You have to have the allegations which are indicated. Then government may be satisfied and the reference can be made.
What is their case? The respondent union?
I don't think they will argue that. I hope so. A settlement which is sought to be impugned has to be scanned and scrutinized. Subsection 1 and 3 of section 18 divides settlements into 2 categories, namely 1, those arrived at outside the conciliation proceedings, and 2, those arrived at in course of conciliation proceedings. A settlement which belongs to the first category has a limited application in that it merely binds the parties to the agreement, but the settlement belonging to the second category has an extended application since it is binding on all parties to the industrial disputes, to all others who are summoned to appear in the conciliation proceedings, and to all the persons employed in the establishment or part of the establishment, as the case may be, to which the dispute related on the date of the dispute, and to all others which joined the establishment thereof. The settlement arrived in course of conciliation proceedings with a recognized majority union will be binding on all workmen of the establishment, even those who belong to the minority union which had objected to the same. The recognized union having majority of the members is expected to protect the legitimate interest of the labor and enter into a settlement in the best interest of the labor. This is with the object to uphold the sanctity of settlement, reach to the active assistance of the conciliation officer, and to discourage an individual employee or a minority union from scuttling the settlement. When a settlement is arrived at during the conciliation proceeding, it is binding on the members of the workers' union as laid down by section 18(3)(d) of the Act. It would be ipso facto binding all the existing workers who are all parties to the industrial disputes and who may not be members of the unions that are signatory to such settlement under 12(3). The Act is based on the principle of collective bargaining for resolving industrial disputes. For industrial democracy is the bedrock of the Act, as pointed out in so-and-so. In all these negotiations based on collective bargaining, the individual workman necessarily recedes to the background. Settlements will encompass all the disputes existing at the time of a settlement except those specifically left out. There can be many splinter groups. This is what is important. There can be many splinter groups, each forming a separate trade union under Section 4 of the Trade Unions Act. And any 7 or more members of a trade union can get the trade union registered under that Act. If every trade union having a few members is to go on raising a dispute and the state government making reference again and again, the very purpose of settlement is defeated. Once there is a representative union, which in the present case is the labor union, it is difficult to see the role of the workers' union. If there are a number of trade unions registered under the Trade Union Act, not entitled to be registered as representative unions and they raise disputes, industrial peace should be far cry. Under Section so-and-so of the Rajasthan Act, Representation Act means the union for the timing registered under as a representative union, the Rajasthan Act and all that, that is local obligation, you know. But the ours is all recognized union, 6 of them have signed the last settlement. So the idea is that you can't allow splinter groups to take away the benefit of that settlement. No. What is seen there is, my lord, if you raise a dispute against a settlement, it is the majority character which is first asserted. If you are having the majority, then only you can raise a dispute with regard to an existing settlement. Otherwise not. That is mentioned, my lord, at page 395, just before paragraph 26 starts. Notice given by the workers under subsection 2 of 19 of the Act is obviously invalid, as it did not represent the majority of the persons bound by the settlement, nor it is a representative union. In this view of the matter, it is not necessary for us to consider what were the demands raised by the workers' union in charter which are not covered by the free practice. Yes. Paragraph 4, my lord. Oh no, I'm sorry. 2005 8 SCC, page 49. It starts at page 45 of your compilation, my lord.
2005
Huh?
PSSC.
Huh? State of Uttaranchal versus Jagpal Singh. Page 44.
Yes.
Para 4, page 50, my lord. Internal page 50 and
Yes.
para 4. We find the approach of both Labour Court and High Court clearly wrong on wrong premises. If there was a dispute on the question as to whether the settlement was bona fide or was obtained by fraud, misrepresentation, or concealment of facts, the same can only be the subject matter of another industrial dispute. That's what I see. To substantiate the averments that such settlement could not have been arrived at, nothing was brought on record by the respondent and employee to show that there was any pressure exercised or that he was subjected to undue influence. There is no material to show that the settlement was intended to frustrate the order passed by the High Court. At no point of time the respondent employee raised any dispute as regards the fairness of the settlement. Having obtained the benefit, this is what I am relying. Having obtained the benefit, it was not open to him to turn down without justifiable reasons to contend that the settlement was not fair. All these employees, my lord, who came into the new union, everyone was getting the benefits of the settlement. They have all enjoyed that benefit.
When these two unions were formed?
We have a lot of unions apparently. 6 unions have signed.
No, these two respondents.
They have, one is a recognized union local. No? Oh, at that time, oh, I see. At that time, this union was not recognized. That's what I am saying.
Our union was in January 2015. That your lordship will get in our affidavit.
Okay.
The repetitions.
At that time, it was not.
Yeah, paragraph 2, they have stated.
Yes. Oh, till now.
It is there.
It's not a recognized union.
Recognized?
No.
Registered trade union, it is their case.
No. Registered has to be, otherwise you can't.
Respondent formed in 2015. And there is a process of recognition also.
Yes.
It is not recognized.
No.
So far, our case is concerned, it is not at all recorded. No,
I'm asking.
Different footings.
Ah.
Anyway, we have to answer this point.
Next case, my lord, is 2002 3 SCC 411.
Yes.
2005, maybe?
2002, area 40, page 46 of my lord's comparison.
2003. Diana. How about that?
Paragraph 15. Paragraph 15, my lord, at page 420.
Yes. Baroni.
It's 55. It's a reiteration of the earlier one, no? As the settlement, paragraph 15, as the settlement entered into the course of conciliatory proceedings assumed crucial importance in the present case, it is necessary for us to recapitulate the fairly well settled legal position and principles concerning the binding effect of the settlement and the grounds on which the settlement is vulnerable to attack in an industrial adjudication. Analyzing the scope, relative scope of various clauses of section 18, this court in Baroni, I have already referred to a case which has quoted that your lordship need not trouble yourself with this. The same thing is there. Paragraph 15, 19.
21 to 26.
19.
19.
19 is Robertson again.
Yes, yes. It is also referred to in the earlier case I have mentioned.
Nineteen and paragraph
21 and 20.
40.
21 and 26.
21 and
21.
26. 21 bits and pieces, it should not be looked at.
21, then 26.
20. It is all right, it's not that. Maybe a little piece of. It will be for it. And my lord, I am coming to the some case on pay parity, equal pay for equal work. No. 2019, 7, volume 7, SCC 658, para 39 and 40.
Age?
Hmm?
90. 90.
Para 30,
39 and 40.
no, para 30,
Para?
para 31st, my lord, at page,
35.
page 670.
670.
30.
Yeah, 30 also is 86.
Page 86, no?
Para 30, 86. Yes.
It may be noticed that there are no pleadings on record, and primarily the burden was on the respondent applicants to establish that the duties discharged by each of the employees was same and similar to that of a regular stroke direct employee appointed or employed by the establishment, and this can be discerned from the facts pleaded in the application filed by one Jagu by of which reference has been made. In absence of an initial burden being discharged in the first instance by the respondent employees, the onus could not have been shifted upon the appellant's sale to counter the nature of the work discharged by each of the workmen as to whether it was the same or similar to that of the permanent regular employee of the establishment, and how far the principles of equal pay for equal work claimed as enshrined under Article 14 and 39 D of the Constitution of India would be attracted in the facts of the case. So it is the burden of the workers to establish that they are doing the same and similar work in order to claim the same wages. And on that, the finding your lordship has seen at page 75 that they are not entirely identical. That seals the position. In paragraph. Para 39, my lord. Page 90. To make it further clear, Rule 25 of the 71 rules, of which there was an emphasis before the High Court, may not come to the rescue of the respondent employees for the reason that it was an obligation upon the contractor who are holding a license under Section 12 of the Act, and as per the terms and conditions of the license granted under Sub-Rule 1 of Rule 25 or renewed under Rule 29 to comply with certain conditions enumerated under Sub-Rule 2 of Rule 25 of rules of 71, which includes 4 and 5 to be complied with by the contractor. And if at all there is any breach of the conditions of license, complaint can be made to the prescribed authority and its consequences are embedded under the scheme of the Clara 70. Yes, we need one. Okay, what else will I- no. 40. At the same time, an obligation to provide immunities conferred by Act to the workers has been referred to under Chapter 5 of CLARA, and the primary responsibility is of the contractor that each worker employed by him as a contract laborer has to be paid his due before the expiry of such as may be prescribed, with an exception provided in 24. One, in case of the contractor fails to make the payment of wages within the prescribed period, or makes short payment, then the principal of employer shall be liable to make the payment. So, the principal employer pays to the contractor, he has to pay, and he has to maintain the records. But if he defaults, the principal employer has to pay. That's the provision in the and the
You don't
contractor.
think today it will be completed?
Huh? Oh,
Almost 4.
oh.
I don't think it will take how much time? It might roll over to next week.
More to. 2 days will not be possible. I will not take much time left. Maximum 1 hour.
1 hour, but yes. Next Thursday? If not inconvenient?
Not inconvenient.
He knows my problem, but.
না, কালই করো ফোন। কালি করো, আপনি যাবো তো। ঠিক আছে, করো।
You will not be available.
No, he will go to Delhi. His brother is coming from USA.
Okay.
He is a patient.
Okay.
So he told me all these things. So I
Okay.
was all right.
Can we complete by 4:30?
No, I don't want to trouble. Below, that's not a fair.
No, it's okay.
No, I won't.
No, 4:30 is in schedule time.
Oh, schedule time. Oh,
Yes.
shit. I'll try to finish it.
If you can finish, then it will not be a problem.
When
Then I can argue.
later,
No.
I'll come and.
No, yeah, whenever you will come. Try to finish it, if possible.
Or if the decisions are to be referred to, he can refer to the paragraphs.
You can do it. No?
He can refer to the paragraphs, we will read together.
Yes.
Right. Then thereafter, Mr. Dasgupta will start. If the judgments are to be referred to, Mr. Kolita can also read.
Yes, he knows better than me.
He can read only. I'll not ask any question. I'll just read together.
No, I'll finish the judgments part and then your lordship schedule time is 4:30. 4:30. Then I have to, because I don't want your lordship to remain beyond the schedule time. That is not done according to Chagla.
After some meeting. So otherwise, I used to seek no bar to continue beyond 4:30. But there's some meeting.
Oh, today.
After 4:30.
I can go up to
Yes.
4:30. Then it's okay. Now, next minute, the head is equal pay for equal work. There I have given a few cases. That aspect is clearly known to your lordship below. What are the relevant considerations to be taken to come to a conclusion that these two groups are doing the same work? I need not really trouble your lordship much, but I'll give a judgment which will, this is mirror 2007-13 SCC 231. Page 93 of your lordship. Para 6 and 7. Para 6. the principle of equal pay for equal work has undergone a sea change. Earlier, the view of this court was that if two persons are discharging the same functions, they will be entitled to same wages. Subsequently, this view has been changed, and now the view of this court is that there should be complete and total identity between the two persons similarly situated so as to grant equal pay for equal work. Recently, this court has held that identity between two persons has to be complete and total. In case of a regular appointee, he has undergone a selection process and his services are regular. Even if a daily wage employee is discharging the same functions as a regular employee, the authorities are not bound to grant equal pay to such a person who is appointing on daily wage basis, that is appointed for a short term and has not faced the selection process. Thus, the principle of equal pay for equal work has to be granted only if there is a total and complete identity between the two persons. In this view, we are supported by a decision of this court in S.C. Chandra versus State of Jharkhand. And this is mirrored at page 2007, 8 SCC 279. That is also part of the compilation. There are two judgments, one by Justice Kajju, the other by in the aforesaid decision, one of us, Kajju, in his concurring judgment, has held that granting pay scale is an executive or legislative function and not a judicial function. There is a separation of powers under the Constitution between the three organs, and the state judiciary should not encroach into the domain of other organs. Montesquieu's theory of property and all that. Then, Miller, I'll give you only the reference 2017, 1 SCC, page 148. Page 96 onwards, that I don't want to trouble your lordship. I'll only show what was given after holding that there are certain people who were really performing the same and similar work. So that finding was arrived at, and to them this relief is given, which is, your lordship will see at paragraph 39 and 40. No? No. There are 61 at page 224.
192. Page 192.
You kindly see the finding at 60. They have come to a conclusion that they are doing the same thing, both regular and daily rated. And then what is the relief granted? Page para 61.
Page number,
Page number 224. Or here 193. In view of the position expressed by us in the foregoing paragraph, we have no hesitation in holding that all the temporary employees concerned in the present bunch of cases would be entitled to draw wages at the minimum of the pay scale at the lowest grade in the regular pay scale extended to regular employees holding the same post. Even after recording a finding that they are doing the same thing, this is the relief granted, and which our 2010 settlement gave in 2010 also. 7 years prior to this judgment. Educational qualification is mentioned here at paragraph 7. Page 197, no? Paragraph 7. No, I have to hold to a Mewara.
Yes.
Paragraph 8, we got. 7. Para 7 and 8. Even para 7, even assuming that the petitioner performs similar duties and function as those performed by an audiologist, it is not sufficient to uphold his claim for equal pay. As already observed in judging the equality of work for the purpose of equal pay, regard must be had not only to the duties and function, but also to the educational qualification, qualitative difference, and the measures of responsibility prescribed for the respective posts, even if the duties and functions are of a similar nature. But if the educational qualification prescribed for the two posts are different, and there is difference in measure of responsibility, the principle of equal pay for equal work would not apply. Under the relevant rules, then it goes on. And paragraph 8, Milord, about there are several decisions of this court where educational qualifications have been recognized as a valid basis for classification. Because the mode of appointment is important, and qualification also is important in considering these two questions. Paragraph 4 also, your lordships can note. In paragraph 4 and 5 both, Milord. Same thing is reiterated, Milord.
Yeah.
The application of the doctrine would arise where employees are equal in every respect, but they are denied equality in matters relating to the scale of pay. That's the principle. Upubuntu. 98(1) SCC 422. Paragraph 15. Hey, one more nalagin. The next case is 98(1) SCC, page 422. At 2010, you know.
210.
210.
Paragraph 15.
Paragraph 14, 15. It was said also, Miller, at paragraph 15. It is also settled proposition that the evaluation such jobs for the purpose of pay scales must be left to expert body unless there are any malified, its evaluation should be accepted. In federation of so-and-so, equal pay for equal work is a fundamental right, but equal pay must depend upon the nature of the work done. It cannot be judged by the mere volume of work. There may be qualitative difference as regards to responsibility, reliability and responsibility. Functions may be the same, but the responsibilities make a difference. One cannot deny that often the difference is a matter of degree and there is an element of value judgment by those who are charged with the administration in fixing the scales of pay and other conditions of service. So long as such value judgment is made bona fide, reasonably, on an intelligible criteria, which has a rational link such with the object of differentiation, such differentiation will not amount to discrimination. It is important to emphasize that equal pay for equal work is a concomitant of Article 14 of the Constitution, but it follows naturally that equal pay for unequal work will be a negation of that. Hmm? Para 17 also, Miller, on facts, we have seen that the mode of recruitment, these are the elements, Miller, which are taken into account. The mode of recruitment, qualification, promotion are totally different in the case of appointments of lower division and upper division in the secretariat, and in case of lower and upper division in the directorate of reform. This ground is sufficient for fixing different scales. So you have to take into account the mode of recruitment, the qualification part, and Miller, the responsibility. And for that, Miller, it is not merely a statement from the worker, but something more is required. The next case is Miller 2019. 2009, I'm sorry, 2009, 17 SEC 318. Para 14, Miller. The last 3 lines of the para 14, there is no discussion at all by the Labour Commissioner as to how he arrived at the conclusion about similarity of work. The evidence let in by the parties and the material placed by them.
Paragraph 14.
14, the last 3 lines. There is no discussion at all by the Labour Commissioner as to how he arrived at the conclusion about similarity work. The evidence let in by the parties and the material placed by them seem to have not at all been considered by the Labour Commissioner. The trouble here is, my lord, the statements were only taken. The required evidence to justify that policy and the scale and the settlement, which can only be spoken to by the oil company, they were not in the picture at all. They were bothered to take them.
So what I could gather is that impugn order was by the Deputy Labour Commissioner. In the manner in which he has arrived, that is not sustainable. And second part is that since a settlement, binding settlement is there, by virtue of 18(1)(d), the respondent unions have to abide by the settlement. I think this perhaps
Absolutely.
these are the two
Two.
primary contention.
Cannot come and raise the same dispute over again. Unless they raise a dispute about the bona fides of the settlement, which they have never done. No, just go to judgment, huh? No. Yeah, I have read from that only. Paragraph 14.
Yes.
I have read it. Then the 15, the High Court also is not looked at the matter of the relevant part. And then paragraph 16, we are afraid the consideration of the question as to whether the workmen employed by the contractors in the second filtration plant perform the same or similar kind of work as the employees directly employed by the principal employer in the main plant by the Labour Commissioner as well as the High Court is highly unsatisfactory. In a situation such as this, we are constrained to set aside the impugned judgment of the High Court as well as the order of so-and-so passed by the Labour Commissioner, Uttar Pradesh. The application made by the Union under 25A is restored to the file of Labour Commissioner Kanpur for fresh consideration in accordance with it.
So if it is set aside, then again it must be remanded.
Yes.
It has to be remanded.
If your lordship says that he has not taken the evidence or the parties have not adduced the evidence and the relevant tests have been applied and yet he has given the full relief, then obviously it may involve also a remand.
I have read paragraph 15.
Yes.
This is against us. Paragraph 15. So responsibility is cast. Both single bench, division bench.
Yes, that's right.
So court has to be conscious now because of paragraph 15.
No, your lordship. You're not be worried about that.
No, nowadays these type of paragraphs are coming thick and fast.
The only thing is, my lord, there is no court above the Supreme Court. Otherwise, I think the same thing should be said in many cases. This is the case which has been referred to by, in that earlier case of Justice Kaju. 2007 13 SCC 231.
279.
Page
1, 2, 8. No. Oh. No, 2007 13 SCC 231. That is by Kaju, which I have placed total identity he was talking of, and he is referring to another case, which is 2007 8 SCC 279. This is the case. And Justice Mothur's judgment starts at page 289 and relevant part at paragraph 21, and Justice Kaju's starts at 290 and paragraph 27, 28, 29, 36, and 37. But it is the same thing, states that it has to be absolutely identical and you must consider that. That is what I said. Fixation of
now
this-
one query.
Yes, please.
Suppose these are the two, say, principal limb of submission. Now, if the settlement in the course of conciliation process is arrived at between few recognized unions, then by virtue of section 18(1)(d) or 3D, it is binding on others also who subsequently join.
Yes.
That is one. Suppose these respondent unions, the settlement is binding on them.
They are members.
Non-members also, others are also.
Yes, anyone.
This can be one.
Anyone working there will be bound. And these members of this new union, they are getting the same benefit. They are enjoying that same benefit.
So if that proposition is to be accepted, then deputy labor commissioners exercise resulting into that impugn order, if it is set aside, then how can it be remanded?
No, I'm not talking about remand.
That is because it will be in conflict. But here in this judgment, just we have see that paragraph 15 I said, no?
Yes.
Paragraph 15 I said, there paragraph 16 is restored to the file of labor commissioner.
Yes.
Whether if there was no settlement, then it can be remanded.
Correct.
So my
Yeah, absolutely.
thinking,
Absolutely.
if there is binding settlement,
Yes.
then there is no question of.
Yes, yes, yes.
Your
That will be
lordship-
their case. If
Absolutely.
they
That will be their case.
If the binding is there,
No, no, I'm
Huh.
the other things are irrelevant.
Had it been a case that there is no binding settlement.
correct.
In that case, that matter can be relegated because he has not done the exercise properly to
Correct.
find out equal pay for equal work.
Absolutely.
Okay, remand the matter again.
No, no.
That can be a possibility. But here is a case, there is a settlement.
Settlement.
Whether that is binding on them or not, that is the question.
If it binds,
Then
question-
no relegation,
No.
no remand.
No remand.
No, no.
Second point is not at all essential.
Yes.
No, no, I am not.
If it
saying
is
that-
binding,
No, no,
it is-
I am, some
No.
questions are.
if it is binding, then procedural aspect is meaningless.
No, no.
It is binding on us.
Correct. That is why. I'm
That is
saying
his
that
case.
So, no, because I am looking at this kind of matter for the first time, so some questions are,
Very pertinent.
some questions are there.
Very pertinent.
Because we have read few paragraphs, but background is also necessary sometimes.
Absolutely right. And
Yes.
when your lordship
Whether-
says whether it is a remand, I should have really replied in the way your lordship is thinking.
Yes.
I did not do that. But your
So-
lordship's view is absolutely correct, because if it is binding, there is no
Then
question
other-
of a remand.
Other person is meaningless.
Absolutely.
If it is binding.
But otherwise also, I am not asking for a remand in this matter.
No.
Yeah.
But some questions cropped up.
Yes, my answer was a little equivocal. So it is good that your lordship has put the matter in the right. Sorry. There are 27 key questions. And that is at page 290.
236.
Yes.
2007, it is
230?
236. Apart from case. The 25.
Para 26 below. Fixation of pay scale is a delicate mechanism which requires various considerations, including financial capacity, responsibility, educational qualification, mode of appointment, and it has a cascading effect. Hence, in a subsequent decision of this court, the principle of equal pay for equal work has been considerably watered down, and it has hardly ever been applied by the courts in recent years. So again, that expert body thing is. Wholesale identity, that is what was emphasized. And at page 294, para 36 also, it is well settled by the Supreme Court that only because the nature of the work is the same, irrespective of educational qualification, mode of appointment, experience, and other relevant, the principle of equal pay for equal work cannot apply. This is fairly well settled. Same thing. You know, the next case is 93-1 SCC 539.
Page 241.
Out of paper book.
241 page,
241.
paragraph 12 and 13.
11, 12 and 13 is 246.
240?
6.
It's 12 and 13. Material above goes to show that A, the qualification prescribed by the lecturers in higher secondary and the non-technical lecturers are the same. Service condition of both the categories are the same. The status of the school also is the same. There is, however, a conspicuous absence of any clear allegation and or material suggesting that functions and responsibilities of both categories of lecturers are similar. Much less is there an allegation of proof that qualitatively speaking, they pursue similar functions. It is not enough to say that qualifications are same, nor is it enough to say that that the schools are the same status. It is also not sufficient to say that service conditions are similar. What is more important and crucial is whether they discharge the same duties, functions, responsibility. On this score, there is a noticeable absence of material. Whether we look at the available and the materials produced along with it, the original petition to be heard in the counter or so and so, we do not find any clear material to show that the duties, functions, responsibility of both categories of lecture are identical or similar. In that context, it will be appropriate to refer to the definition of the expression same work or similar work contained in Equal Remuneration Act so and so. 1976, the said act was enacted by Parliament to implement Article 39D of the Constitution, an obligation created by the Convention concerning equal remuneration for men and women in education. And then the definition of same and similar work means work in respect of which skill, effort, and responsibility required are the same when performed under similar conditions by a man or a woman, and the difference, if any, between skill, effort, and responsibility required of them are not included. It would be evident from this definition that the stress is upon similarity of skill, effort, responsibility when performed under similar conditions. Further, as pointed out by Mukherjee J. in Federation of Science, the quality of work may vary from post to post. It may vary from institution to institution. We cannot ignore or overlook this reality. It is not a matter of assumption, but one of proof. The respondents, original petitioners, have failed to establish that their duties, responsibilities, and functions are similar to those of non-technical lecturers of technical colleges. They have also failed to establish that the distinguish between their pay scale and that of the non-technical lecturer working in technique is either irrational and it has no basis, or it is vitiated by nullified either in law or fact. It must be remembered that since the plea of equal pay for equal work has to be examined with reference to Article 14, the burden is upon the petitioners to establish their right to equal pay, or the plea of discrimination as the case may be. This burden the original petitioners have failed to discharge. That's the same case here, mirrored before the, he never took any evidence. If you only the statements of regular employees and the 12 and 13, he has taken that. And there is a new judgment my learned friend has just got. This is mirrored. You don't talk as an this is in your lordships.
249.
249.
Okay, I'll look into it.
Okay. Oh, I'm sorry.
Next Thursday, Mr.
Yes, we all can see this is all the same.
Before PK, and senior counsel yesterday. Anything to be added in the main submission?
No,
আগতেই মোটামুটি আগতেই মোটামুটি
Counsel for the
খবর নিয়ে যাও
petitions.
Fact that-
Senior counsel. Agor order to tax. List the case. Next Thursday?
Oh, no, 20 Thursdays, another case speak, not.
But তুমি পিছত মাৰ্চত কৰি দিয়া মোৰতো অলমষ্ট শেষ হ'ল।
No, not to hear. I'm not here.
মই থাকি যাম। আৰম্ভ কৰিবা। Subject to your lordship convenience, could it be on Tuesday, my lord?
Fixed matter. That is, huh?
Vacations.
Third March কইল জানো আপনি সেইদিনা শেষ কৰিব নোৱাৰিব হা
তুমি কৰ মানডেটো নকৰো।
24, there will be difficulty.
March, let it be in March.
Huh?
মূল আপত্তি না আপনি যদি করে করবে subject to your lordship convenience any date.
Then 5th of March,
No problem.
Thursday.
Any date. Except 26.
5th of March.
5th of March or a little.
No, মই argument কৰিম তাৰপিছত
তাৰপিছত ঠিক আছে, ঠিক আছে।
No problem.
Okay, as sought for by Mr. Dasgupta. With the agreement of the land council for the other sides, list the case on for further hearing. There is one case on Tuesday. If starts, it might go on for the day.
I will not take.
Speaks now.
5th of March, Thursday,
No problem.
because that is the only next hearing day after 26th.
No, before 26 also you can not fix.
26th, for me it is possible.
No, 20 another case is fixed. That is the problem.
24th is not possible.
Justice Bolwar's court.
24th is not possible.
They very difficult to get German in that country.
Then 5th of March or 7th of March for.
No problem.
Subject to his lordship convenience.
Subject to lordship
No, 5th of March.